If you have a final order of removal or deportation, is there anything that you can do? Yes, many people can. Did you know that for $155, you could file an application directly with ICE to stay your removal? That's Form 246 ICE form. You submit all the reasons why you seek to have your order of removal stayed. And that it could be many factors, like you're going to file a motion to reopen, or you have medical issues, or your family has medical issues, or you're the sole parent of a child that's in the US that needs to be cared for, or you have sole custody of children that need to be cared for. There's a whole host of reasons, and you just need to get with a lawyer who can flush those reasons out. And you submit all the proof with the application. Now, it's in the sole discretion of the Department of Homeland Security ICE officers if they're going to grant this or deny this. You can file it at the office that's closest to your house, the ICE office, or if your loved one is detained, that has to go to the field office that has jurisdiction over where your loved one is currently being detained. And that could be, who knows, but you'll find out when you contact ICE. You have to have a current passport that's valid for 6 months past the period of time that you're requesting the stay. So if you're requesting a year, then you need to have the passport be current for at least a year and 6 months. You have to submit the passport or a copy of the passport in order to have the stay of removal granted. If you've just applied for that passport, make sure you keep copies of that, and you can actually submit that to ICE, knowing, and then they'll know that your passport is in process. Many people that have an order of removal, they want to seek a motion to reopen that removal order. And that's one of the reasons why you would want the stay of removal from ICE. And you can also file a request for an automatic stay with your motion to reopen too. The factors that ICE look at is your entire immigration history, your entire criminal history, and the hardship grounds or the reasons why you should be granted the stay. There is no refund of the fees if ICE denies this application. Yes, you can reapply, but usually it's one and done. If you have a good lawyer, they should submit all the documents that they possibly can and declarations to support the application. If you're granted the stay, you're actually put into supervision. And did you know you can file for a work permit then? Yes. You have an order of removal, you're granted the stay, and now you're under supervision. And as long as you comply with supervision, meaning you might have to check in, they might put an ankle monitor on, you might have to call, you might have to physically go in. If you're under that order of supervision, there's a specific code and you can actually file for a work permit. I've done that for many of my clients that were just about to be deported. They were under supervision. They hired me. I filed the motion to reopen, and they didn't even know that because they were under the open order of supervision, they were able to get a work permit. So it changes people's lives. This is just one remedy that you might consider consulting with an immigration attorney about filing now or possibly when you're detained. Remember, it's important now to gather these documents, right? School records of your kids, medical records of your kids. Maybe you have medical issues. Maybe your spouse does. Copies of any immigration applications you filed, and so on and so on. Because if you're detained, you're going to need your loved one to gather these documents. You might as well gather them now and put them in a binder. Like, share, and follow. I'm Gloria Cardenas, the immigration queen, with many years of experience handling these types of matters.